Our next case is case number 2023-3422, Duval County Public Schools and Lewis James versus Jackson and Johnson.
Okay, please report. Good morning, I'm Sonia Harrell, along with my co-counsel Amy Grass-Gilmore, and we represent the appellants in this case, the Duval County School Board and Lewis James. The school board, I'd like to reserve 5 minutes for rebuttal. The school board and Mr. James were immune not only from liability, but from suit. And the lower court deprived them of that immunity by not granting their motion for summary judgment, even though there was no basis for depriving them of that immunity in the record. I'd first like to start to talk about the school board's sovereign immunity, and then I'll discuss Mr. Lewis's individual immunity. The issue with regard to the school board's sovereign immunity is very simple. To invoke this statutory waiver of sovereign immunity, a claimant has to present notice of her claim in writing to the affected agency, and unless it's a municipality or a county, she also has to present her claim in writing.
Was the school board noticed?
The school board did not receive statutory notice. They received maybe constructive notice. But
So it got sent to the general counsel's office, correct?
it did get sent.
And your office does represent the school board.
That's correct, Your Honor. But the plain language of the statute does not say to send it to the attorney for the agency. It says to send it to the agency. And there's no record of any notice being sent directly to Duval County School Board.
Does the statute say to send it to the janitor at the school board?
It just says to the agency.
To the agency, so anyone at the agency.
That's correct.
So an attorney wouldn't qualify?
Perhaps if the agency is in-house at the school, if the attorney is in-house at the agency.
To the agency by way of their attorney?
The statute says the agency. The statute doesn't say by way of their attorney. You can imagine a case in which an attorney represents several local governments, let's say, and sending it to the law firm, sending notice of the claim to a private law firm would not suffice.
Doesn't your local ordinance tell them to do this?
Our local ordinance says to send it to the Office of General Counsel, and they did that. They specify the ordinance.
And you represent, again, I'm just trying to clarify, you do represent the school board, correct?
That's
You're representing the school board here as the city attorney's office, correct?
That is correct, and we've got a consolidated government, so it's a little bit more.
I'll ask you about that in a minute, but I'll go ahead and let you finish, Judge McGovern.
Government agencies don't let corporations have registered agents?
I am not sure, Your Honor. I think they can, but in this
All I'm
case,
really getting at is when it says to serve the agency, that's not quite as clear cut, I think, as you're making it out to be.
it says that it has to serve the agency, and maybe that is the attorney. But the statute also says they have to serve the Department of Financial Services. And Ms. Johnson's failure to do that in this case is fatal to her claim, and that's well settled under the Menendez case, and it shows that she's not compliant.
The judge in his order clearly stated that there was evidence that they did, correct?
That's correct,
Do
Your
you
Honor.
know where I don't see that letter in the record, so do you know where the judge got that?
I do not know where the judge got it. I can speculate that it may have come from arguments of counsel, whether in the response to the motion for summary judgment
But we
or
don't
at
have
the
a
hearing.
transcript of that,
We
correct?
don't have transcript. And we don't need a transcript in this case because the record of the lower court is, on a summary judgment, is the paper evidence. There was not an evidentiary hearing, there was no testimony taken, and the arguments of counsel at the hearing cannot be considered as summary judgment evidence. So
Nor could they submit new evidence at the summary judgment hearing.
that's correct, Your Honor. There's a specific time frame in the summary judgment rule that says it has to be submitted 20 days before the hearing, and that was not done in
Were there
this
any
case.
concessions at the hearing?
I'm not aware of any, Your Honor. Again, we don't have a record of that hearing, so I can't determine whether there were any concessions. What I do know, though, is that the record itself is devoid of any reference to Ms. Johnson presenting her claim in writing to the Department of Financial Services, and that is fatal to her.
Based on your structure of government, does the school board fall under the umbrella of the municipality so that there would be an exception? Or are they a separate entity in your governmental form?
They are a separate entity in our governmental form, and I'll refer you to the case of City of Jacksonville versus Bowman, which talks a little bit about another independent agency, which is our municipal utility. The consolidated government incorporates the City of Jacksonville along with Duval County.
Are the members independently elected?
The school board members are independently elected.
Do they have independent statutory authority?
They have independent statutory authority, and they are, under our ordinances, considered an independent agency, just like JEA was in the City of Jacksonville versus Bowman case. So even if there's an issue about whether notice to the attorney was sufficient, I know Ms. Johnson has argued that it went to the insurer or the third-party administrator. That's not enough under the statute. But even setting those issues aside, the failure to present the claim to the Department of Financial Services means that no notice was given and there's no waiver of the statutory
Did you
sovereignty.
provide any evidence in your motion that the Department of Financial Services was not noticed? I know you filed an affidavit in regards to the school board, but you did not file one in regards to the Department of Financial Services. Is there a reason for that?
I'm not aware of why that wasn't done, but
Do you think that's a requirement as the moving party that you would need to do that?
as the moving party under the new summary judgment rule, it's not a requirement. We just had to point out the lack of evidence in the record.
But you have to have a basis for saying that, right? You can't just willy-nilly make stuff up, right? And so what was your basis in the record for saying that?
The letter that was sent to the Office of General Counsel is only addressed to the Office of General Counsel. It was not addressed to the Duval County School Board, nor was it
Were there
addressed-
interrogatories or something like that?
There were some requests for admissions.
Okay, request for admissions.
And
And they said they didn't know.
they said they didn't know, which
Who would likely know if they sent the notice?
that would have to be either the claimant, Ms. Johnson, or her attorney.
Right, so if they didn't know if they sent it, would that be a basis for saying that there's nothing in the record to suggest they sent it?
Under the rules governing requests for admissions, saying I don't know is not enough. That can be construed as an admission because it's not proper. It's not a proper denial under Rule 1.37.
They also said therefore denied, correct?
It did say therefore denied.
So is that enough?
That is enough to, we don't think it's enough, but in this case, assuming it, even if it is enough of a denial, the evidence in the record contradicts that denial.
Well,
And the evidence-
taking Judge Eisnabel's question, take out the admissions. Can you just look at the record and say, hey, we've gone through discovery, this letter's not here, we're pointing that out to you, trial court, we want summary judgment evidence. Is that your understanding of the new rule?
That is, Your Honor, and we're basing that on the letter that is addressed only to the Office of General Counsel, not to the Duval County School Board, and not to the Department of Financial Services. There's no CC, DCSB, there's no CC Department of Financial Services, there's no certificate of certified mail, there's
This
no.
is a question I don't know the answer to at all. I assume there were document requests. Were there document requests here?
There were.
Okay. And were those document requests, did you request the notices?
I do not recall off the top of my head whether any notices were
How did you,
requested.
okay. How did you get the notice that, to this? Well,
The notice was sent to our office.
you had your copy of it.
Right, we had one from day one. And
Did they ever produce that notice?
as part of discovery,
I can go back and find it, you don't know?
I don't know, and I don't believe, Your Honor, that any requests for production of documents are in the record, because I don't think they were relied upon by either of the parties at summary judgment. So our basis for asserting that there was no service to DFS is based purely on the only notice letter that's in the record.
Is there any burden shifting here where the status quo here is sovereign immunity, no suit, unless you meet the exception? Now, you're the moving party for summary judgment, so you have those burdens, but what you're essentially saying is you haven't met your burden to overcome the status quo of sovereign immunity. So at which point does it become either your responsibility to show the document wasn't there or their responsibility to show that they met the requirements to overcome the status quo. Walk me through that.
Well, and it depends on probably the drafting of the pleadings, but the worst case scenario for the appellant would be we assert the failure to provide notice as an affirmative defense, which did happen in this case. It's our burden on that. We produce evidence, or we point to evidence in the record, or we can also, under the rule, say there is no evidence, and we can shift the burden. So we could say there's no evidence you ever sent this to the agency or to DFS. Once we do that, and it's a low burden under the new rule. It's not like the old version of the rule where we had to really build a case and disprove the non-moving party's case. So once we say you don't have this notice, the burden then shifts to the appellee, Ms. Johnson, to say, yes, we do, here it is, and here's where we sent it to DFS.
But I think importantly, though, you have to have a basis for saying that, right? Can't
That's
get to the court, all that stuff.
Exactly.
Okay, well, we know that you sent a notice to us. I'm saying you, right? You know, we got this notice, but does that mean we didn't send it somewhere else? I'm not sure, is that a basis by itself?
So typically what we see in these letters is,
No, I know typically you would see like a CC or it'd be both addresses, right? But there's nothing in the statute that requires that. That they could just send you a notice with your address and then send a notice elsewhere with their address, right? They could do that. There's nothing in the statute that says they can't.
that's correct.
Okay, so how is it a basis to say, hey, they didn't send this elsewhere? Just because on your letter, it doesn't show a carbon copy or something.
So we can also draw an inference from the fact that the school board did not directly see the letter. And there is an affidavit in the record to that effect. So,
I'm talking about the department.
oh, right, and so they send one just to OGC. They don't send one to the school board. We can reasonably infer that since they didn't send one to DCSB, they must not have sent one to DFS. And it's also not the typical pattern we see by seeing it CC'd on the letter that was sent to us.
That might be your better argument. I'm not sure, because again, I mean, you're the lawyer for the school board, right? So it's not clear to me that they needed to send it to somebody at the school board too. That's not clear to me. I think your better argument is they didn't send it to the department.
Well, and that's fine, that would be enough, because failing to send it to the department is fatal.
And walk us into your individual immunity argument.
Certainly, Your Honor. So the individual immunity is also granted under section 768-28. And typically, the employee of the government who commits a tort will be liable, will not be individually liable. The agency, municipality, or county will be vicariously liable for their actions. And that's entitled to sovereign immunity. That vicarious liability disappears, though, if the employee acts outside the scope of his employment or acts in a manner that is willful, wanton, with malice, or in bad faith.
How was, I think the allegations were that he hit the student multiple times in the head, causing injuries?
The allegations are that he hit her 3 times in the head. Those are the allegations of the pleading.
How does that not take him out of his realm of duty at that, of being an employee at that point?
Well, he's working to break up a fight among,
So that would be a question to the jury, it would seem to me, at that point. So is the trial court correct in denying that portion of your motion?
no, Your Honor, and the reason is because it's just a simple battery at that point. There has to be something more to show.
Was there evidence in the record, though? There's a video, there is an evidence in the record showing that he did hit her, correct?
The evidence in the record says that he punched her, and that's based on her interrogatories answers.
Multiple times?
The interrogatories don't say multiple times. The interrogatories say punched.
If this force is excessive, does that take him outside the scope?
Not necessarily. There's a case we've cited, Butler versus Galtieri, that talks about excessive force used by a police officer and gives examples of when excessive force becomes willful, wanton, malicious, or in bad faith, such to remove that individual immunity. And some of those examples, some of the examples that the court in that case gave were an officer sat on a diabetic man who was in a coma for several minutes. A police officer grabbing a person being arrested and kicking. Those did not rise to the level of willful and wanton conduct, such
Those
as
summary
we were
judgment
doing.
cases?
Those were, I don't remember if that one is, it's the Butler versus Gualtieri.
That's important, right, whether, in this case?
It is, and it was, I believe that was actually the motion to dismiss stage.
Okay.
And so the court in the Butler case said, if a police officer grabbing an arrestee and kicking him is not willful and wanton, and 3 officers sitting on top of an ill diabetic man until he goes limp is not willful and wanton, then we don't see how these actions could be. But they said there was an issue of fact in that case, because you had some statements of the officer in that case cursing at the arrestee and acting really agitated. There's no evidence of that in this case. All we have is a statement saying, he punched me. A reasonable jury from that can't find that he acted willfully and wantonly. I know
Do we know what the allegations for her the injuries were?
the injuries are that she had a brain injury. But the injuries don't necessarily.
And went to the hospital?
And went to the hospital. The injuries don't necessarily relate to Mr. James' state of mind, though. Rita's injuries happen all the
Is it state of mind a
time.
jury question also?
Yeah, I mean, isn't there an inference there that, you know,
Not,
there's a punch and then there's a punch that sends you to the hospital with a brain injury, right?
well, you could have a brain injury arising from a car accident that results from negligence. And so without more, there's not enough for.
Well, the forces in a car accident are potentially far greater than a punch.
Sure, but again, we're not looking at the force, we're looking at the intent.
You're reading your rebuttal time.
Sure. I just, in some, asked the court to refer to the previous decision in Lemay versus Condrick, and it defines willful and wanton negligence, and will reserve our remaining time for rebuttal.
Mr. Dempsey?
Yes, sir.
You can come up over, sir.
Good morning, Your Honors. Donald Dempsey on behalf of the appellees, Joanna Jackson and Aisha Johnson, in this action. Your Honors,
How do you not know if you sent a notice to the department?
the argument was that that same letter was sent to all parties involved, as well as the department, all from the agencies. We sent notices to the police department, the principal himself, the school, everyone involved.
Only one that matters here is DFS.
Yes,
You send one to DFS.
Yes, that same notice was sent
So
to
you
DFS.
sent that notice to DFS?
Yes, and in response to requests for production of documents, the request number 17 addressed what notes in terms of compliance with both statutes, local ordinance, as well as 768.28.
Did you attach the letter to the Department of Financial Services to your response? I saw one to the school board, but I did not see one to the response. Was there a reason why you didn't attach that letter also? To your response to the motion for summary judgment. You attached the letter to the general counsel's office. I didn't see one to the Department of Financial Services. Was there a reason why you did not do that?
No, that was the actual same letter that was provided, in terms of the letter addressed to the general counsel's office was the same letter that was given to the department.
Okay, so you sent the same exact letter, you just didn't have the department's address on it.
That's the only thing I did.
Did you make that, did you put that in evidence in the summary judgment proceeding? And if so,
Yes.
where? Is there an affidavit saying, yes, we sent that? Is there summary judgment evidence in opposition to the
Proof of
motion?
mailing, anything.
I mean, look, you probably could have just done an affidavit saying, yeah, we sent it to the department too. I don't even know that you had to show a copy of anything, but is there any evidence in the summary judgment record?
It was more argument, Your Honor, in references to the request for production of documents in terms of saying compliance as to how we complied with the statute.
So you're saying the trial court's decision was based on an argument that you made at the hearing
And
as to your production of documents?
and the exhibit itself saying exactly this was what was produced in terms of satisfying the requirements as far as notice to the department, end up giving that notice. And with the state, well, Your Honor, with the appellants arguing strict compliance in this case, the reason the second document comes into place is because the only response that we received from the entity was, in fact, a response from their insurer requesting additional information in terms of discovery and providing that information to them. It's our position that on our worst day, they've engaged in the claims process. It's, I believe, intellectually dishonest for them to come to court and argue a lack of notice when they've investigated a case or a claim for over a year, and then say, hey, you haven't given us notice as to what was going on in terms of this case.
It's not giving them notice. It's not giving notice to a separate entity in the state, which is a statutory requirement.
And we believe that we satisfy that by giving notice to their counsel, to that entity, to the Department of Financial Services, as well as having.
But the two questions here become, number one, did they meet their burden? Did they have a basis for saying that the notice wasn't sent? And then if they did you oppose the summary judgment with counter evidence, which the rule requires, right?
Yes, sir.
The rule doesn't say you can just show up to the hearing and argue it. The rule says you must file the evidence and designate it as summary judgment evidence. I can't remember what the current rule says, but some days before the hearing.
Yes, sir.
And so if they met their burden by having a basis for making the allegation that there was no notice to the department, then at that point, you would have had to, in the summary judgment evidence, present some kind of affidavit, something, to say, yes, we did. If you didn't do that, then the only question left is, did they meet their burden? Did they have a basis for saying it wasn't done? Right?
Yes, Your Honor. And my understanding as to what we did in that case was composite Exhibit B with respect to the letter that was sent to the city, as well as the response from their insurer, was our response to say, hey, this is our affirmative evidence that we did in fact comply with the requirements for filing the lawsuit.
Where was that? You said Exhibit B?
Composite Exhibit B.
Of what?
That would just be the letter to the counsel as well as the letter from the insurer.
You're referring to your summary judgment.
To my summary judgment.
The summary judgment response?
Yes, sir.
Okay.
You made some arguments about the lack of a transcript being fatal. Why is that the case?
Well, with respect to the arguments, as far as our position is that the appellants in this case are simply asking this court to weigh the evidence and question the credibility of the affirmative evidence presented by the plaintiff in this action, replacing your judgment for that of the lower court, which we believe is not appropriate for motions of a summary judgment. Both federal law states that everything is supposed to be taken in light and favorable to the non-moving party, that being the plaintiff in this action, and that the court is not supposed to enter the weighing of evidence or questioning of credibility of the evidence that's presented at that point in time. With respect to the requirements, the rule in this case is simple. The correct test for the existence of a genuine issue, material fact, is whether the evidence is such that a reasonable jury could return a verdict in favor of the non-moving party. We believe we satisfied our burden with that. If they want to come back and question again and everything else, well then that's where we believe the court exercised its discretion saying, I believe this case is best suited to be decided at trial on the merits.
You're talking about the individual now?
Yes. In terms of going forward. With respect to the individual immunity for Jesus, we believe that they did meet their burden. We believe that the photos, videotape, answering interrogatories, and medical records prove his affirmative actions in terms of punching a minor child in the face 3 times, causing brain injury and having her permanent injuries for the rest of her life.
Where do you draw the line? Because the approach you're taking completely obviates the immunity. There's no such thing as the individual immunity if the question of did he act within his scope is always a jury question. Then there's no such thing as immunity from suit. So where does the line get drawn between what facts go to the jury and what facts have to be decided beforehand to decide if there's immunity from suit?
Your Honor, I would say on a case-by-case basis, you would look at the actual evidence of what occurred as far as from the plaintiff's perspective and whatever defenses were offered from the other side in terms of evidence as far as the filter as to what goes to the jury, what doesn't go to the jury. I think the line has to be drawn at
Counsel, is
It comes back to the question.
is it what a reasonable, is it when the evidence presented, that a reasonable jury could reach the conclusion that there was no immunity based upon the evidence presented in the summary judgment proceeding? What evidence did you present in the summary judgment proceeding from which a reasonable jury, right, could conclude that that the punches were outside the scope?
That would be the photos, the medical records, and her answers to interrogatories. In this case.
Is it your position that a reasonable jury could look at that evidence and could conclude that we were outside the scope in this case?
Yes. That was our position.
Isn't that the result of the action though? The result of the action doesn't determine the scope. The action itself determines the scope.
What getting into the fact of 3 punches as far as his responsibilities in terms of what his job was and the safety of the children and one of those children being injured, I believe intentionally based on affirmative punches from that individual would then bring him outside the scope. And it's not so much in terms of what his responsibilities were for the job description that he had and the actions taken, we believe would then put it beyond the scope. If this was simply her falling down and all of a sudden we were suing them because she fell down and everything else or was pushed into something, that'd be different. Here we have him actively acting, and we believe that with the evidence and the opportunity to be shown in terms of what was given to the court, that was enough in terms of us meeting our burden. We simply have to ask that this case be decided on the merits and not mere technicalities as presented by the state, or excuse me, the appellants in this action.
Anything else?
No.
Okay, thank you, sir.
May it please the court. The evidence in the record with regard to Mr. James's actions consists of the photographs, which simply show him standing there. They do not show 3 punches. The other evidence is the interrogatory answers that say he punched me. Doesn't say 3 times. No reasonable juror could find on those facts that he, with reckless indifference to the consequences, consciously and intentionally did some wrongful act. And that is the standard this court has set out for willful and wanton conduct in LeMay versus Condor. Compliance with the rules, whether the summary judgment rules requiring the production of evidence or with the rules to invoke sovereign immunity, are not mere technicalities. They're rules that have to be followed to make sure.
So it's your position that the result of the punch or punches or 3 or however many were, it's your position that the result of the punch or the punches is irrelevant? A reasonable jury couldn't look at the result and conclude, whoa, there's a punch and then there's a punch, right?
Under the evidence that's before the court, no, a reasonable jury could not return that because the evidence is he punched me.
And
not 3 times.
She
and I had a brain
hospital.
injury. And there are
How long was she in
photos of
hospital?
him showing. Several weeks, I believe.
Several weeks.
I don't know if that's due to the brain injury, but again, the brain injury could have been caused by, there's no evidence in the record that that was not caused by, a reasonable jury could find that it was caused by some other.
Okay, tell us what evidence in the record, where in the record can we conclude that?
There was a fight among several high school girls, some of whom were out together.
Right.
Then we have screenshots of Mr. James standing there. And we have her saying he punched me, and then there are some references in the interrogatories.
It just sounds like something for a jury to decide.
Based on that limited evidence, though, it doesn't rise to that higher level. Is it whether he committed the regular tort of battery such that the school board would be liable for it? That would probably be a jury question.
So a reasonable jury, weeks in the hospital with a brain injury, punched perhaps, once or twice or 3 times, who knows? But all that, no reasonable jury could conclude that he was outside the scope.
That's correct. Because of the context of breaking up the fight. He could have been defending himself He could have just been part of that fracas that was going on. You have to go a step beyond to go to his state of mind. And none of the evidence upon which Ms. Johnson relies goes to his state of mind.
Do they have to read his mind?
mind?
What do they have to do?
No, there has to be some other evidence.
What about several weeks in the hospital with a brain injury?
Goes to the severity of the injury, but not to his
Tell me
state of mind.
how they would read his mind. Give me some examples.
They don't have to read his mind, but they do have to, there has to be some evidence of, maybe he's standing there saying, I'm gonna get you, Kaish.
So he's got to verbalize it.
He doesn't have to verbalize it, but maybe there's a witness that saw him giving a mean look, and maybe saw him punching her aggressively,
So a
repeatedly.
mean look is enough.
A mean look
Weeks
may
in the
not be
hospital
enough,
with a brain injury is not enough.
because the injury does not go to his state of mind.
It goes to the force, potentially.
It
Does it
does,
not?
it might be, but, if he's doing something else that doesn't require brute force, you could have brute force without willful and wanton and conscious disregard of the facts. Again, we have a very limited record here. It's not enough for a reasonable jury to decide these issues. We ask that the court reverse the summary judgment and remain it with instructions to enter summary judgment in favor of the school board and Mr. James. Thank you.
Thank you. And thank you for both of you. It was a well-argued case, and that concludes the cases that we have this morning. If the attorneys are excused, if you would like, we're going to probably take some questions from the school, from the schools that are here. We're not going to talk about the cases, so we'll let you know that. So